I explained that very clearly. I think I explained it actually to both sides during the couple of final settlement conferences that we had. So I don't know why it's being raised. They have elected throughout these number of years to have the case remain here. So at this point, I'm not removing it. What do we have? Everybody from Pittsfield PD here? Does Pittsfield have anybody on the road? I mean, I'm just thinking.
The fire department's here.
Yeah, everybody's here. You guys take care. Thank you, Mr. Schiller.
Thank you.
Can you, Mr. Schiller, can you approach on a separate matter? Court does call the case of Finney versus Sedona. The first thing, you guys are going to have to switch sides. State your appearances, please.
Good morning, Your Honor. This is Megan Dalvala on behalf of the plaintiff, P84205. Mayor, can you state your name?
My name is Maria Finney.
Peterson.
All right. It's a date set some time ago for a non-jury trial. Are the parties ready to proceed?
Your Honor, may I approach the bench and go off the record briefly before I begin? I have a procedural issue.
A procedural issue?
Yes, I can stay on the record.
That's fine.
Oh. May I
What?
approach-
No, well, then I've got to have them up here.
Sure.
I guess, what is it?
Okay, so there is a counterclaim, which is what this is separate full trial. There was already an order of eviction entered. I'm intending to move for summary disposition under C8 and C10. I need the opportunity to brief that issue.
Well, why am I here on the date of trial with that?
Right. So the last motion that was filed, it was back in July. I appreciate that this is a long time coming. So please, Your Honor, I'm not appreciating that at the court's time. However, I'm recently retained, and there's about 1,000 pages worth of evidence. This has gone to mediation. There's conflicts in the facts, even in what was submitted during mediation, and there's significant evidence indicating issues of fraud upon the court and other issues regarding insurance fraud by the defendants. And it is my professional opinion that it does substantiate claims under MCR 2.116 C8 and C10.
Well, the motion should have been brought before today.
Okay.
I mean, I don't know what particular issues you're talking about in terms of somebody committing fraud upon the court. And I'm just going to say this, if they were going to say this about the other side, if you're going to make that accusation, counsel, you better bring it. And it better be that, because if it's not, then I'm going to be exceedingly angry, because I don't like people. I do not like people accusing others of things like that without substantial proof.
Absolutely. It is a substantial issue in this case. My client's rights have been significantly violated.
By whom?
By former tenants. This started out as a non-payment of rent case. As I mentioned, there was an eviction action, there was an order of eviction. As you're aware, we're here on the bench trial for the counterclaim. I don't take a claim of fraud upon the court lightly. There is significant evidence to present that. And I don't want to disparage my client's rights by not attempting to have this dismissed under C8 and C10.
Well, I get it, but there was an attorney in this before.
He's exceedingly difficult to get a hold of. That was part of why I asked to approach the bench, but I understand there's something.
He was in court here Monday, so I don't know why he's not that difficult to get a hold of.
Okay.
coming in on the date of trial, asking for an adjournment of these proceedings is not going to happen.
Okay,
So you guys either can try to resolve this thing, or we're going to try it.
okay, fair enough. Then I would request a brief recess to please speak to the defense.
Okay, see if you guys can work it out. Court's going to stand in recess.
14A District Court back in session, the Honorable Jake Sederson.
You may be seated. Back on the record, court does call the case Finney versus Sedona. All the parties are present, and how did the conversation go?
It wasn't entirely productive, Your Honor. So we have, back from 2021, a consent order for conditional dismissal. There was an eviction order entered after that time against the defendants. As it relates to today's full bench trial, it is based on a counterclaim that was filed on February 12th, 2021. However, again, it's my position that the counterclaim needs to be dismissed. There's not actual cognizable claims under the counterclaim, so that it would be right for dismissal under MCR 2.116C.
Why are they not cognizable claims?
The claims are not cognizable as defendants are now pro per in this case. This was filed by their previous counsel. There is not a cognizable claim in regard to the condition of the property as against my client for relief.
Why is that not cognizable?
Can you repeat the question?
Why is that not cognizable claim?
It's not a cognizable claim, Your Honor, because there is a conditional dismissal entered as it relates to the original complaint where the defendants were being sued for the non-payment of rent, where the counterclaim asserts a generalized claim without any sort of reference to a breach of habitability or constructive eviction. The way that it's written in this counterclaim, it's more pertinent to the affirmative defenses given the case history here and the fact that there was an eviction order entered. At this time, this can't be a cognizable claim before the court.
That doesn't even make any sense. If somebody says I paid $1,000 or rent was $1,000 a month, I didn't pay the $1,000, and actually I was living in conditions that I think the landlord may owe me money because I paid them or something happened to the unit. The very fact that there was an agreement to vacate the premises doesn't negate their claim for money. As it wouldn't the landlord, if the landlord had a claim for money.
Absolutely, Your Honor. My point is more towards, to back up slightly, this has been in court for a long time. There's a lot on the record, especially for something that started out as a non-payment of rent case. The defendants are the relatives of the plaintiff.
I'm aware. I'm aware of a whole lot in this case.
There are facts in the counterclaim that are very generalized. There's not a factual section or actual claims after that. It's very generalized, but it does assert that there's a dispute as to mortgage payments. There's a dispute as to ownership interest. So this is out of the realm of a landlord-tenant non-payment of rent case. And it's not a cognizable claim under the statutory law for those damages. Secondly,
And you keep saying that. Give me some case law that says that.
Okay. May I move on to a second point briefly and then return to that, Your Honor?
Go ahead.
Okay. Secondly, after the generalized facts in the complaint, then the defendants move on to enter under a claim of statutory conversion, common law conversion, excuse me. Well, okay.
Regarding the insurance money.
It's both. In paragraph 28, it's combined into common law conversion and conversion under MCL 600.2919A. Now, again, of course, Your Honor, we're considering what the language actually is in the counter complaint, but it's to my point that these claims are entirely convoluted. But they're asking for, as you would be entitled to under statutory conversion, 3 times the amount of actual damages plus costs and reasonable attorney's fees. If there's no summary proceedings to be had in terms of the possession of the property, and what's at issue here are ownership interests and statutory conversion claim that exceeds $25,000, it's in the beginning, as I was arguing to you, that this would be appropriate for dismissal under MCR 2.116C7. However, even if
Jurisdictionally or under 7? Why under 7?
right, this is what I'm stating, Your Honor. In the beginning, maybe it wasn't helpful to move on to a different issue, but in the beginning, it's that there aren't cognizable claims that apply any longer, given the procedural history. Not only that, but also just the way that it's been written out here in terms of the habitability. I did need a brief moment to consult my information, but in terms of the habitability, the actual counts that would indicate that the legal requirements have been met are not enumerated. And then secondly, it would be appropriate under MCR 4.002, not necessarily to dismiss the action, but if it's related to property ownership, which is quiet title, and if it's related to conversion for a claim of over $25,000, it's not the court's obligation to dismiss it, but it would be more proper that this be transferred to the circuit court.
And have you asked for removal?
I would request a removal, Your Honor.
I'm not removing this case.
Okay.
I think it was, and you coming late to the game, I think I explained to the Sidonians I don't have jurisdiction over the title.
Okay.
I also explained to them that my jurisdictional limit was 25,000. I explained that very clearly. I think I explained it actually to both sides during the couple of final settlement conferences that we had. So I don't know why it's being raised. They have elected throughout these number of years to have the case remain here. So at this point, I'm not removing it. Anything else?
I mean, I have to object to proceeding on a full hearing at this time. For
On what grounds?
the numerous reasons I've stated.
You've stated a lot of gobbledygook is the only way I can explain it. You haven't given me a reason. You haven't given me a reason why it shouldn't proceed today. This matter has been set for trial today. I have given a lot of leeway to both parties, I think, in terms of trying to make sure to try to resolve this case, to try to find a way to do it, sent them to mediation. They went through basically a mediation with me regarding this case on a couple of occasions. And it's come down to the date of trial. And now you come in wanting further delay. And I'm not delaying this anymore.
It's not that at all, Your Honor. I just want to do right by my client. I was hoping I could approach the bench. I understand there's not another attorney and a party will also have to be able to. But I would like to go off the record for a moment if it's acceptable to you.
Do you have any objection to that, folks? No. All right. I don't know how we're going to have this conversation, but let's do it this way. We can go off the record. Mr. Trapp, take both parties and behave yourself when you're in my hallway. Take them back to the jury deliberation room. When you're seated in the deliberation room, I don't want either one of you saying anything to anybody until I get there. We clear? Ma'am, am I clear,
Yes.
Miss Finney? All right, take them back to my jury deliberation room. And the court will. Sure.
When we came back in, she asked us to step out in the hallway. And when we stepped out in the hallway, she proceeded to tell us that pretty much if we don't take the $5,200 in escrow and walk away today, that she's gonna file a lawsuit against us in a different court, that you won't be our judge, and it'll be over $25,000. So no money matters. She didn't want to talk about the money matters again. So she said escrow only. So I just leave it in your hands, Your Honor. I don't know what to do anymore.
Completely misconstruing what I said. And we shouldn't even be talking about settlement matters, but I made a valid settlement.
Counselor, if you don't want to talk about it, don't talk about it.
Yeah,
It's not going to make a difference to me.
right.
I mean, I'm just going to say this. I mean, we go back there and talk. Your client, I'm going to let you put the testimony on, but there are certain representations that she's made to this court that you may or may not be aware of, because you got caught with one. I'm not saying caught in the sense of whatever, of a statement that she made, which is absolutely contrary to what she said before.
Right.
All right, are we ready to try this?
To be let off the case at this time?
You're looking to withdraw?
Yes. I can't reasonably represent her if I'm going to misconstrue the facts.
Well, it's not an issue of you misconstruing the facts. I'm just telling you that there have been certain representations made on the record, which I will tell you were different than what was said today. And I will tell you, counsel, I can tell by your reaction that you did not know that. So if you are going to move to withdraw, I'm going to step off, and you probably need to have a detailed conversation with your client about that. The court's going to stand in recess. Everybody can remain seated. Court does call the case of Finney versus Sedona. Parties are present. The record should reflect I've had an opportunity to talk with the parties, and parties have come to a resolution. I'll state it on the record and then ask for the concurrence that that is the agreement. Parties have agreed to a full and final settlement of all claims that could have been raised in this case or have been raised in the amount of $10,000. That will be in favor of the Sedonians. That $10,000, the amount of $5,263.17 will be released to the defendants from court escrow. The remaining amount of $4,736.83 will be paid by Ms. Finney to the Sedonians in monthly payments over a 2-year period. And counsel, that amount, what was the amount per month that you came up with?
That was $197.33.
All right, per month for 2 years. When did she wish to begin those payments?
Next month.
April? Okay. Is there a particular date in April?
I think the 30th.
The April 30th? Would that be acceptable to? All right. Beginning April 30th, 2025, until that is paid in full. Should the defendant miss a payment, default on the payments, an additional amount of $5,000 will be added to the $10,000 figure. The Sedones would then be entitled to a judgment in that amount, less any payments, which is inclusive of the escrow that have been made. All right. Also, I am the oral motion of counsel to withdraw once the order has been prepared. I will grant that, so that after that, the order is signed, she will have no further obligation to this case unless she undertakes it in some other way. That's the court's full understanding of the agreement of the parties. I'll start with you, Ms. Finney. Is that your understanding? Do you have any questions whatsoever regarding that? And I will ask this because of what occurred. You are satisfied with the efforts of your attorney in representing you today in this matter?
Yes.
All right, great. To the Sedones. Mrs. Sidoni, is that your understanding of the agreement?
Yes.
Do you have any questions regarding that agreement? And you are satisfied with that agreement? Mr. Sidoni, is that your understanding of the agreement?
Yes.
Do you have any questions regarding the agreement? And are you satisfied with the agreement?
Every courtroom tells two stories. One is written in legal documents, motions, and evidence. The other is written in the decisions people make when the pressure is at its highest. This case became a powerful reminder that preparation, credibility, and honesty can influence the outcome just as much as the law itself. As the hearing unfolded, arguments grew more intense. Claims were challenged, procedures were questioned, and the court demanded more than opinions. It demanded proof. In the courtroom, serious allegations carry serious consequences, and every statement must be backed by evidence. When last-minute requests threatened to delay the proceedings, the court made it clear that justice cannot wait forever. Cases move forward, deadlines matter, and every party is expected to arrive prepared. It was a reminder that timing can be just as important as the arguments themselves. One of the most revealing moments came when confidence began to collide with conflicting facts. As questions mounted, it became clear that trust between attorney and client can be tested when the courtroom uncovers inconsistencies. In legal disputes, credibility is often the strongest evidence a person has and the easiest thing to lose. Rather than continuing down a path of uncertainty, both sides ultimately chose resolution over prolonged conflict. The agreement marked the end of years of litigation, proving that even the most difficult legal battles can conclude through compromise instead of a final verdict. In the end, this case wasn't simply about who was right or wrong. It was about the importance of preparation, accountability, and the responsibility that comes with every decision made inside a courtroom. Justice is not measured only by who wins a case, but by whether the truth can withstand every question asked along the way. Because when the courtroom doors close, the arguments are over, but the consequences of every decision can last for years.